All right, everyone. Good evening. My name's Franck Magennis. I'm a communist, a barrister called to the Bar of England and Wales in 2016, practicing here in London, and I'm the co-founding director of Riverway to the Sea, the host of tonight's meeting. The International Day of the Endangered Lawyer is observed annually on January the 24th to raise awareness about the threats, intimidation, and persecution faced by lawyers worldwide for fulfilling their professional duties. And each year, the event focuses on lawyers in a specific country. This year, 2026, the focus is on the United States of America. The purpose of the Day of the Endangered Lawyer is to highlight broader challenges to the rule of law, to human rights, and it's organized by a coalition of legal groups. And the day itself, which is in 2 days' time, involves reports, petitions, and events to advocate for legal professionals who risk their lives to ensure access to justice. Tonight's event is being organized by Riverway to the Sea. Our organization examines and confronts the problems posed globally by Zionism, by the apartheid state of Israel, and by its imperialist backers in the United States, Britain, and other imperialist states. We do this by entering into a problem-posing dialogue with the people and organizations who are engaged in the most militant and the most effective forms of anti-Zionist struggle. So our strategy as an organization focuses on, but is not limited to, the countries of Britain, Ireland, Germany, the United States, and Palestine. And through evolving dialogue with our anti-Zionist strategic partners, we facilitate accessible education, we organize cultural activities, and we take strategic action in and beyond the courtroom, all of which is premised on the central principle that the best defense against Zionism is a good offense. So in short, our organization exists to confront Zionism. Now, the participants of tonight's event are invited to follow Riverway to the Sea on social media, which will be posted in the chat shortly, the links to our social media. Our website is currently under construction and it's soon to be relaunched, so watch this space. We have made tonight's event, like almost all of our events, a free event. But if you support our work, the anti-Zionist strategy that we're attempting to pursue and forge together, then we'd be very grateful to you if you'd consider making a donation. There should be 3 donation links posted in the chat with the option of donating 5, 10, or 20 pounds. In just a moment then, turning to tonight's event, we'll be hearing from 3 inspiring lawyers who are deeply committed to and embedded in the struggle for Palestinian liberation. Firstly, Nadia Daqqa is a Palestinian human rights lawyer in Jerusalem and niece of martyr Walid Daqqa. Stanley Cohen is a veteran anti-Zionist lawyer based in New York. And Fahad Ansari is a civil liberties solicitor and co-director of Riverway to the Sea here in London. Now, there will be time for questions and answers from the panel towards the end of tonight's event. If you want to ask such a question, please put it in the chat, and you should feel free to mention when asking your question your name and perhaps your organization, or indeed, if you want to remain anonymous when asking a question, that's also fine. And I'll review the questions and try. We won't have time to get through all of them, unfortunately, but I'll do my best to select the questions that strike me as being the most apposite and relevant. So without further ado, then we'll kick off tonight's event by hearing from Nadia Daqqa. Over to you, Nadia.
Good evening, everyone. It's an honor for me to be with you tonight. My name is Nadia Daqqa, and I'm Palestinian, but at the same time a citizen of Israel. For those who may not know, when Israel was established, a group of Palestinian remains on their land. So I'm part of this group, and people often refer to us as the Palestinian of 48. I studied at Tel Aviv University and became a member of the Israeli Bar Association. So by definition, I am an Israeli lawyer. I initially worked in civil law, and at the same time, I began to develop an interest in human rights. This path led me to work at a human rights organization called Hamoked, Center for the Defense of the Individual, an Israeli NGOs. And in my work there, I focused on the rights of detainees within the context of occupation. In most cases, these were Palestinian detainees classified as security prisoners. I also worked in a very specific field that originated in British law and was adopted by the occupying authorities, the punitive house demolitions. And working in these areas has never been easy. We don't use to win our cases. It is extremely challenging, and it comes with the deep personal difficulties because you are constantly witnessing a severe violation of the most basic human rights, including policies of collective punishment. At the same time, it feels somehow strange for me to speak about myself as someone who is being targeted because of her work, when my daily work is focused on speaking about the people I represent and the grave violation of their rights. But when I reflect on it, especially after the past 2 years of what I describe as a genocidal war, it has truly becoming an inherent part of the Israeli policy against Palestinians. And lawyers are being targeted as part of a broader strategy and as a tool of repression against the communities they represent, and in this case, the Palestinian that they represent. And before I proceed, I want, and it is important for me to note that I'm speaking from a very sensitive position. And my participation in this panel, which is professional and important and entirely legitimate, must be done with great caution. This is due both to the well-known persecution of lawyers working in this field and to my own identity. For example, statements that may sound completely reasonable and widely accepted in an international context can provoke hostility in the Israeli context and may place the person who voices them at risk. And one example is the fact that we are talking about an occupying entity, and under international law, there is a recognition that unoccupied people has the right to resist this occupation. In the Palestinian case, this is not a temporary occupation, but rather a process of settlement and colonization. From this point alone, any act by a Palestinian to resist occupation is treated as a criminal act and addressed through a legal system similar to the ordinary criminal law. So since I began working in this field, I have represented Palestinian detainees, specifically regarding their conditions of detention, like in family visits, medical care, and basic rights such as access to books or appropriate equipment. I do not use to represent them in their criminal proceedings or in relation to the acts that lead to their imprisonment, but only regarding their treatment after entering the prison. And the persecution I experienced did not initially stem from this work, rather from my involvement in cases of punitive home demolitions. This is one of the most controversial issues in the Israeli legal system. For those unfamiliar with the policy, we are talking about an essentially form of collective punishment. An individual commits an act, is arrested or killed, and then the authorities come to their family and demolish their home. And this policy has gained public support within Israeli society. And in some cases, even the courts have expressed concern that it is being used to satisfy the public opinion. And in this context, I found myself being harassed by extremist groups who attend every hearing on this issue. They disrupt proceedings, demand that families of Israeli victims be allowed to speak, although they are not part of the procedure, and humiliate me as I enter and leave the courthouse. They shout accusations that I receive foreign funding to represent what they used to call terrorists, and they constantly emphasize my family connection to the prisoner Nadia Daqqa. who died in prison about 2 years ago, and now saying all the time that he rotted in jail. The harassment includes live filming, following me to the courthouse parking lot, and portraying me as a terrorist by myself. They approach me physically, and in some cases use sexually suggestive language. I should also note that in some of these cases, I used to learn about the demolition order through the media before the army even sent the order to me, although I was part of the procedure. And this clearly showed that the legal process is very symbolic, and the main goal is to demonstrate to the Israeli public how they can punish Palestinians, even though in most cases the family affected have no connection to the alleged acts related to their family member. Since this policy reflects mainstream Israeli society so closely, the courts are not eager to intervene in these cases. In some cases, judges who have expressed opposition to the policy have themselves been threatened. My requests to the court system for basic protection, such as preventing these groups from attending hearings or keeping them away from me inside the courtroom, or providing safe space where I could wait for hearings away from them and their cameras, were simply ignored. And I also know lawyers who, because of this persecution, choose to stop representing cases of this kind. And this, I think, in my opinion, is absolutely understandable. I continue to do this work and have no intention to stop, but I must say that the sense of threat has intensified over the past 2 years. When I leave the courthouse, I enter a public space, and as is well known, much of the population in Israel is armed. Accusations linking me to terrorism can easily put my life in risk. What makes this even harder is that attempts to file police complaints for harassment were not addressed at all. And this means that I and other lawyers like me are left without protection. Over the past 2 years, the overall treatment of lawyers has significantly worsened. Human rights organizations working in these areas have faced campaigns aimed at cutting off their fundings, an accusation that is commonly raised in similar contexts. It is important also to understand that this situation is an inherent part of the populism that increased and has penetrated Israel's bureaucratic and judicial systems, and in fact is the real side of the policy. Alongside the genocidal war outside, we have witnessed a parallel war taking place inside prison walls, far from media cameras. From the beginning, when we tried to meet Palestinian detainees, visits were delayed and scheduled far into the future. Even when we arrived, visits were denied under the claim that a state of emergency had been declared inside the prison. Later, visits were partially allowed, but every lawyer entering prison experienced a dramatic change in the behavior of the officers working there. And we were treated as suspects by ourselves. The treatment was harsh and humiliating. Searches were extremely invasive. In some prison, I was required to undress in front of a female guard to prove I was not hiding prohibited items in my bra. Our documents were inspected in ways that violated attorney-client privilege. There was no way to object because the visit itself was conditional on these searches. Later, the authorities began prohibiting documents written in Arabic, prohibit from entering the visit room documents written in Arabic, the language of the people we represent and the language we use to communicate with them. Many lawyers were denied entry to prison or summoned for interrogation on suspicions of passing forbidden messages to the prisoners, simply because a piece of paper contained greetings from a prisoner's mother or the names of his children and some facts about them was found between these papers. And for such basic things, lawyers faced bans from entering prisons and even disciplinary or ethical proceedings that endangered their licenses and their work. Last August, similar measures were taken against me, despite there was no specific incident. One day, while I was in the middle of handling numerous petitions regarding prison conditions, I received a letter stating that I was suspected of passing messages between prisoners and that the head of the prison services intended to ban me from entering prisons for 6 months. I filed an objection, and 3 days later, I was informed that the ban was in effect. While the matter was still supposedly internal, a media article was published stating that I had been banned due to serious suspicions of passing messages, emphasizing that I was an Arab lawyer and a relative of Walid Daqqa. My work on the cases I worked on was frozen, and this had a severe impact on my ability to continue working, including a psychological, on a psychological level. About 2 months later, I finally reached the court hearing. The decision to ban me was based on secret evidences, exactly in a similar way to the administrative detention procedure. The judge indicated that the information did not seem strong enough, but was unwilling to issue a clear ruling stating that the IPS was wrong. Instead, the judge suggested reaching an agreement, and at the end of the day, we agreed to a 4 months in total of a ban, and with a commitment not to renew the ban. I had no real choice at that time, and any other legal route could have dragged on far longer, so I decided to accept it. And during this process, I just remember that in one of the recent hearings on house demolition, the group harassing me mentioned the number of petitions I had filed during the war regarding the detention condition of the so-called terrorists. I cannot be sure 100%, but I feel that the ban was connected to monitoring the volume of petition I had submitted at that time. The whole situation is grim, and it is extremely sensitive for anyone working in this field. But for those committed to human rights, especially in this period, giving up was never a privilege we had. We have witnessed another aspect of genocide inside prison walls, and at the level of the explicit policy, one that has even received backing from the court itself. And a very good example that I like to use is the case of the Gazawi detainees. Since 2023, thousands, for who don't know, thousands of detainees from Gaza Strip have been held in custody. And at the beginning, they were held in conditions of absolute enforced disappearance. And unfortunately, this occurred with the passive acceptance of the Israeli court. After extensive legal proceedings, lawyers' visits were eventually permitted. Beyond the professional and legal aspects of our visit to these detainees, especially, another crucial element emerged, the human element, the human one. At the end of the day, yes, we are lawyers, but first of all, we are human beings. And when you meet a person who left their entire family behind in the hell of war, that visit allows them to understand that their family is alive and has reached out to a lawyer in order to visit them. That alone caused many detainees to break down in tears because it was the first sign of life they had received from their families. And when the goal of the system is to isolate detainees completely and to operate in a manner that violates the minimal standards of detention as defined under international law, it becomes very easy to understand why the system placed obstacles in the way of lawyers accessing prisons. And indeed, they succeeded in delaying our work. It is no coincidence that around 50 lawyers were prevented during this specific period from entering prisons for extended lengths of time, a fact that itself demonstrates that the importance of these visits and their critical role in exposing and challenging detention conditions.
Thank you so much, Nadia, for that incredibly insightful contribution. Let's turn now to Stanley in New York. Over to you, Stanley.
Nadia, and you are aware of what she struggles with and the process, the beast, the belly of the beast that she walks in against every day, 24 hours, 7 days a week. It makes the oppression that's targeted against we in the global north that practice human rights law de minimis. And I have nothing but absolute respect to Nadia. Once upon a time, I would go to Palestine. I would go to what's called Israel fairly often to see clients until I was banned by Israel, I don't know, 15 years ago. And then I was banned by Egypt in 2014 because I sued them in the African Union. So my family in Palestine I've been unable to get to on the ground. Let me say this, and I think it sort of sums it up. My great-grandmother was an anti-Zionist Jew. My grandfather and his brother were accused of trying to assassinate the Tsar. She had to put them on a boat and send them to Africa. One stayed in Africa and the other came to the United States. My father was an anti-Zionist Jew, and I grew up in a household where Yiddish was spoken fluently. He fought Nazis and helped to liberate concentration camps, but he was also anti-Zionist Jew. So I grew up in a household that was empowered with the drive for humanity and decency and history and understanding. And this notion that this 150-year-old death cult all of a sudden grows up one day to take the lead of a 5,000-year-old faith is a distortion that is pervasive and permeates the judicial process. I have a story that'll explain my relationship to the Israeli judicial system. Maybe 20 years ago, 25 years ago, I was arguing in a case on appeal on behalf of Lower East Side squatters, people that had seized buildings, homeless people in the appellate division. And during the middle of the argument, a group of 7 or 8 women and men came in and watched the argument. And when it was done, they came up to me and said, Mr. Cohen, they introduced themselves. We know your reputation. We had no idea you were this skilled. We'd like to introduce ourselves. We are, and they went on to identify themselves as a collective of Israeli judges, including one from the Supreme Court, that were in the United States looking at our judicial system. And with my usual flair for I couldn't avoid the moment, I said, I didn't know Israel had judges. And they dropped their heads, basically, had no idea how to respond, and walked away. With that as a background, I have been honored and privileged to represent Palestinians, both on the ground and the diaspora community, and those that have been designated as FTOs for many years. I was honored to successfully represent. It began my representation of Hamas over 30 years ago, when Musa Abu Marzouk, who had a green card in the United States and a family, who was one of the original founders and the head of the leader of its political wing, was first taken in for violation of the green card, and then Israel, the Knesset, issued an arrest warrant. The political body issues an arrest warrant because of the Intifada for Abu Marzouk. And I represented him for 2 years while in custody. We probably spent 5,000 hours in discussions. We would meet every night, 4 nights a week for 2 or 3 hours. The vast majority of which had nothing to do with this case, but reality, politics, life, love, family, community. And I think what sums up Abu Marzouk was if he wanted to call me and if I was not around, he would assume I would be visiting my elderly parents. So I walked into my elderly parents' apartment one day, and all of a sudden I heard my mother say, "Musa, are they feeding you okay? Are they taking care of you?" So here is this 75-year-old Jewish woman, anti-Zionist, who comes from Russia, who was designated as the leader of the political wing of Hamas, having a warm talk, talking about his family, talking about my family, and concerned about whether he was being fed properly and taken care of. "Mom, give me the phone. Give me the phone." She gave me the phone. I took the phone. As a result of my work with Abu Marzouk, he was released. He was removed to Amman, Jordan. And as a result of my work on behalf of Abu Marzouk, it's been my honor, my privilege to spend now 30 years representing alleged members of Hamas and public members of Hamas, the movement, in various procedures and courts in the United States, overseas. It's been my honor to challenge Israel beginning in the year 2000. And it's interesting, I brought the first suit against Israel for genocide then, because for those people who think it's genocide the last 2 years, open eyes, it's been genocide for 100 years, well before the United Nations stole Israel from Palestine. And it was interesting because when we brought the suit against Israel in the year 2000, I believe, Israel tried to ban me from going to see my clients in both the West Bank and Gaza. And we got a federal judge to issue an order saying, "I'm going to hold it against Israel. It's an adverse presumption if you don't allow him to meet with his attorneys." The other successful argument that we litigated was we were able to get the names of our clients released or reduced to Mary Jane or Joe Doe or Fred Doe, because we convinced the federal court that under the Israeli system of quote unquote justice, they would be subject to retaliation. And the court granted it. So in that light, I've spent decades representing Palestinians as well in the United States. Recently, a number of them that have been targeted with the most recent attack by Trump and this administration against Palestinians. The most recent attack by AIPAC and ADL on justice, on dignity, on liberty, on voice in the United States. Over the years, we've had numerous cases. Most recently, I was successful with a group of other lawyers in representing a number of students at Columbia University that were targeted for their protest. Several years ago, I was honored to represent one of the original prisoners who was released as part of the first so-called prisoner exchange. And interestingly enough, after they were released from custody for the first time, Donald Trump's administration tried to issue an extradition order on the basis of a conviction that went back 20 years that the United States never opposed, never took a position on, never supported in any way, but did it for political reasons. We were able to prevail, fortunately, because the extradition treaty had not been resolved. In that light, since this is a discussion about the attack on lawyers, I've had a pretty explosive issue in the United States. On the one hand, we are privileged in the United States as attorneys. We grow up in law school being taught we're the best, the brightest, the prettiest. It's sort of inculcated that we speak these volumes of almost mythical pronouncements, when most attorneys go to law school because they want to make money, they want to become judges, they want to become part of the ruling class. Although I have been very fortunate as an attorney for many years, I've had dozens and dozens of externs and interns and young lawyers that have worked with me, many of whom have gone on to become public defenders and international human rights attorneys, almost all of them involved one way or another in representing Palestinians. There's a price to pay. It's not the price to pay that Nadia pays. It's not the price to pay that Fahad is paying at this point, being targeted, but there's a price to pay. They come for us. Not long after I represented Abu Marzouk, I was subject in the United States to investigation for what's called violation of OFAC. I refused to provide information about sources on a case I was pro bono. The government spent almost 10 years investigating me for material support, publicly harassing me. We then switched from that. I've done a lot of work with North American Indian tribes as well. There were accusations that I was involved in criminal activity with Mohawk clients, and that went nowhere. I was arrested on several occasions. I was indicted for seditious conspiracy for representing Mohawks in Canada in a case where the judge finally realized, I brought it up on my own, pro se. I said, Judge, I don't understand how a U.S. citizen can be charged with seditious conspiracy in a country that isn't theirs. It was dismissed. Eventually, I was charged with impeding the IRS when everything else failed. And my partner, de facto partner, rest in peace, the great, brilliant freedom fighter, Lynn F. Stewart. They targeted Lynn forever. And she was convicted of material support. And when she walked out of the courthouse and said, I'll do this 2.5 years standing on my head, the Second Circuit on its own jacked the sentence up to 10 years. Lynn eventually passed of cancer. She got out of prison after 4 or 5 years. Anthony Serra, another famous American lawyer from the West Coast, went to prison twice. I went to prison in the United States once for 10 months. And as part of the punishment, when I got out, my license was suspended for a year and a half, and it's been back for 10, 11 years, whatever it is. But there is always the cloud of harassment, of intimidation, of the Bar Association, of mainstream law firms. Recently, I represented a rabbi who was moving to have an Israeli flag taken down in the community in Westchester and Rockland County, and they brought in a 1,500-person Zionist law firm that represents the ADL and has represented Israel. So there were a few of us taking them on, and of course they were spewing charges about us being anti-Semitic and self-hating and the usual rhetoric and the usual rhetorical flair and hate. So there's pressure, not the kind of pressure that Nadia has to undertake every day of her life, every time she walks out of the street, every 24/7 for Fahad. In 2000, for the first time in my life, I had to have security after 9/11, 2001, for almost a year because of the threats that were coming in, because you represent those people. You're a Jew hater. I remind them, I say, well, it's interesting. In Judaism, I'm a great descendant. My great grandfather was Aaron. My great uncle was Moses. And legend has it that Israel, that God wouldn't let them into the Holy Land because they were pagans. I guess I'm a pagan. So I had to have security on the ground for about a year and a half. And it was interesting because I couldn't even get a security firm. And Muslim clients insisted that I have security. There were demonstrations in front of my house by the JDL. There were the Kahanas that were attacking us regularly. When I tried the Abu Ghaith case, Suleiman Abu Ghaith, who is bin Laden's son-in-law in the Southern District, the JDL group, the spinoff, postered the courthouse for 30 blocks around. Get Cohen, the Jew, the self-hating Jew, the Jew hater. He's our enemy. He loves Muslims. And a federal judge called a special session and asked if I wanted U.S. Marshals appointed. I said, absolutely not. So I bring this up, again, in the shadow that I've been there, and I've been there a long time. But as I tell young lawyers, it's nothing compared to what our clients go through. Genocide. I think back on my brothers, Abu Shanab and Ahmed Yassin and Abu Ammar. I've lost probably 20 close family members and friends, Palestinian leaders who have been assassinated, dozens that have been disappeared, hundreds that have been imprisoned. So I've gone through nothing compared to the people that are occupied. We as lawyers, I see our role, and I'm again privileged to be able to say what Nadia cannot and what Fahad increasingly in the UK cannot, which strikes me more and more as Austria in 1933. My job is to break glass ceilings. My job is to say the things that people are fearful of saying as attorneys. My responsibility is to be a litigator and know the law as good as the enemy and to fight them with every tool in my tool chest that I can use. But it's also to make sure that I provide a vehicle to make sure that the voice of my clients gets out there, that voices that are suppressed, that attitudes that are repressed, that people that are targeted for their beliefs are able to communicate. It drives judges nuts in the United States because we do this through mitigation reports. So 30 years ago, I was able to put out a 100-page document on the history of genocide then and on occupation and the development of Hamas and the political movement, and it became part of court papers, and the federal judge almost lost their mind. And there was a battle over whether it could be redacted or sealed, and it was not. And 30 years later, the arguments we pointed out, the enemy that we pointed out, the genocide that we discussed, the oppression that we talked about, the violation of speech, assembly, of association, of faith, the establishment of dozens of laws that benefit Israeli Jews alone, we put it out there 30 years ago. What's changed is Israel no longer hides. What's changed is Israel goes forward with its genocide, could care less about what the world thinks, but yet we have to fight. So for lawyers like Nadia and Fahad and other lawyers, colleagues of mine across the globe, we come from a very proud tradition. We come from a history of standing for the despair, the despised, the disaffected, of being a voice, of beating in courts, of giving them an opportunity to be heard, to resist, to fight, to getting unpopular voices out. And we pay the price. Yes, we often pay the price, but it's a price that we go in with open eyes and a warm heart. And for that, I'm proud. And I am proud to be on a panel with brothers and sisters that have been fighting as well for a long time. And I represented the IRA or some members of the alleged IRA in the United States years ago. And it was then the first time I heard up the Ra. So I'll close this discussion with, and I'm sure the people in the UK will love it. I'll close it with up the Ra. And thank you.
Thank you, Stanley. Thank you so much. Yeah, Chucky Arla, as we say, where I come from. Thank you so much for your contribution, Stanley. Over to you now, Fahad.
That's a pretty hard act to follow. I mean, it's quite embarrassing. I think to Frank, when you're on a platform with people like, giants like Stanley and Nadia, and you talk about what's happened to you, it's so minuscule. It's like, Stanley, you felt de minimis next to Nadia, so just imagine my position next to both of you. It's the only thing I will say is it's probably the beginning of my career progression in alongside you guys. I was born in Ireland and I grew up with stories of lawyers. I mean, it was live time when we were kids, lawyers defending the IRA who were actually targeted in ways which are more familiar in the global south than you would than happens openly as it was happening in Ireland. So Pat Finucane, Rosemary Nelson, these were lawyers who were identified with their clients, who were accused of being sympathetic to the IRA and were gunned down in the most horrific incidents and horrific atrocities. I mean, Pat Finucane was murdered having Sunday lunch with his wife and kids. The British state was acting in collusion with loyalist forces in the north. And the government had to apologize for it many, many decades later, but the fact is it was happening. It was full-scale denial at the time by the government, but for me, the concerning thing is the rhetoric from back then continues today, not just with me, but with any sort of lawyers of movements and clients that the government has a bone to pick with. Now, I've been doing sort of counterterrorism work for quite a long time, and I was discussing with my own lawyers yesterday that because we were in court trying to find out why the police stopped me last August and detained me and took my phone. I can speculate as to why that happened, but we wanted to know for sure. And this was a matter of such sensitivity and that it would compromise national security to tell me that the police and the government are refusing to disclose that to me. And we had this hearing about it yesterday. So, speculating about why that might have happened, I was saying to my lawyers that, look, I've been defending, or not defending, but representing people accused of being members of Al-Qaeda, of ISIS, of God knows who, for many years, successfully. We've managed to get, people who had lost their citizenship because they've been accused of being members of Al-Qaeda and ISIS and being involved in jihad in Syria. We've managed to get their citizenship back, and they're back in the country. And I've never, ever faced the kind of, harassment that I've had for the past, nearly a year. And so the only obvious factor in all of this that changed was that I represented Hamas, who were deemed to be even worse than those other clients. But for me, it wasn't just the actual harassment and the slurs and whatever happened. It's the complete unhinged nature of the attacks. I mean, one is we expect this from Zionists. Zionists are absolutely loopy, and you expect this hysterical reaction from them. But then when they take it to the police or take it to the regulator and they present it to them, you would expect some level of rationality or reasonableness, especially from the regulator who are supposedly lawyers themselves. So when they get a complaint saying that Mr. Ansari questioned the beheaded baby's narrative on October the 7th, and this complaint comes in on October the 8th, and he's questioned this, and this is akin to Holocaust denial. Now, whatever excuse I can make for their state of mind amidst the mass hysteria on the 8th of October, that complaint comes in April 2024 when they write to me and ask me my opinion on this. And it's this sort of strange issue where now, until October 2023, I'd never had a complaint in my life against me with the regulator, and suddenly I've got 3 ongoing investigations. Frank is probably in triple figures by now with his own input. But this is it. It's a disruptive tactic. It's designed to create fear that you might lose your license. Stop talking about the genocide. Stop talking about resistance. Just carry on being a lawyer. So that was happening from October. The complaints began after the genocide, or the intensification of the genocide, let's put it, in October 2023. But then once we represented Hamas in the deprescription application, and some people ask, why did you do it? And one of the main reasons really was to create space. The whole concept of deprescription, the concept of delisting, is to delegitimize, to dehumanize, to prevent that these people are so beyond any form of discussion that you can't actually have a nuanced conversation. You can't talk about them. You can't project to them that they've got goals, objectives, humanity, dignity. And so for all those reasons, we said, well, we have to give them back their humanity, their dignity. These aren't just savages or barbarians as the West tend to depict them to be. But there is a cause behind all this. There's a reason for the violence. There's a justification for the violence. And we need to talk about that. And this was something that you could not do. People who try to have those conversations are being arrested, being reported to employers, being reported to regulators. So for us as lawyers, and we'll have a discussion really about the role of lawyers, but I think so one of the other panelists mentioned, we need to create space. We're not their representatives, we're not their spokespersons, but we are there to create space for them to be able to function, to be able to have dialogue. Someone came to me at an event this week and said, what do you think of applying to prescribe the IDF? And I said, I don't agree with it. I don't agree with prescription. If I agree with prescribing the IDF, then, what difference does that make? I can't have a conversation about them. I mean, I'm in the language of words and conduct war by words. And I think we need to be able to do that and dissect them because it's complete falsehood. And we don't want to make martyrs of them by saying we can't have a conversation about them. Let's have a conversation and let's put the truth against falsehood, and the truth will always prevail against falsehood. So for my troubles anyway, and Frank and Daniel, the other courageous lawyer who were part of our team who took this on, once we went live with this, we got hammered by the press, with the media, regulatory investigations. My firm was denied public indemnity, professional indemnity insurance, which effectively meant we had to restructure. We got death threats, abusive calls. Again, it's almost like a pinch compared to what you guys have gone through. And I just feel that it's the beginning. But the biggest issue was when Robert Jenrick, the former Shadow Home Secretary, so he went on this sort of crusade against me where he tried to get me reported to the police. He said the guy's been reported to counterterrorism police 6 times already. He's still celebrated as a human rights lawyer. He goes on Newsnight. He goes on conferences. He did a very good marketing job for me, actually. A really nice resume on his Twitter thread about me. But he was quite, ticked off, let's say, about the whole thing. OFSI, I think similar to OFAC with you, Stanley, OFSI began an investigation to see if I breached the sanctions, even though we were acting pro bono, but they couldn't seem to understand why would you work pro bono for, these guys. I mean, of all people, why would you work pro bono for them? They couldn't get it. So there must be something. Banking investigations are ongoing with me at the moment as well. So all of this is disruptive, and more than anything, it just really occupies your time. And so you can't actually do what you're meant to be doing, is, challenging the law, representing these Palestinian clients. It's just taking over your time. This sort of then came to a peak with the detention under counterterrorism powers last August, and then the seizure of my phone with all the legally privileged material on it, which the police now have and are sifting through and will decide. They've instructed an independent counsel who has a history of representing the police to sift through my phone and decide what's privileged, what's not. So take with that what you may. Again, the problem goes when you go to court and you try to challenge these things, even the courts are sort of, shaped up against you. So you try to explain to a judge the problem with legally privileged material, and you'd expect a judge to understand this. But then they just have to throw up, call it national security, it's counterterrorism, we have to be able to do our job. And this judge sides with the security state, as always tends to happen. That's worrying. And my concern is that because the intended purpose of the harassment is to silence you, to shut you up. And my problem is no one's ever been able to shut me up. Okay, so I carry on. And people have told me, and many our colleagues in the legal industry have messaged me, delete that tweet, take that off. I have a policy of never deleting tweets, because once you give them, and once they smell a bit of blood and you give them any sort of concession, they just bury you. So I will defend everything I put out there. I will not stay quiet when it comes to a genocide. And that's the problem. I can't stop myself. I keep going. I'll keep until I die. Inshallah, I will be on this struggle. And that means they have to escalate their repression, because if the harassments are working, then it will have to be an arrest at some point. And then we'll have to deal with it, what comes. And maybe in 20 years' time, I'll be talking to another panel like this about my times in prison. But hopefully, and at that time, we'll have a free and liberated Palestine, because that's what all this is about. And I think all of us are in this, and it's not about us, it's about the people we represent, the movements we represent, and about the Palestinian people, because they have been dehumanized. The only reason, and this goes back to my beginning point, the only reason I'm targeted now, it's not because I'm representing Al Qaeda or ISIS, it's because I'm representing Palestinians. That they do not want them to have a voice, they do not want them to have dignity, they do not want them to have honor. And our job is to try to create a space for those conversations to happen. Thank you.
Thank you so much, Fahad, for that incredibly thought-provoking and moving contribution. We're going to turn now to some questions. I have a few questions for the panelists, and then whilst I'm asking and we're hearing the answers to my questions, you're very welcome to put questions in the chat. And as I've said, I'll choose questions to put to the panelists as well. All right. So my first question is for you, Nadia. Many people have commented, or perhaps it just seems obvious, that Zionism is in quite a profound crisis these last 2+ years of genocide in the wake of October 2023. So if it's right that Zionism is in a crisis, can you comment on the role that law and legal proceedings have played in provoking and deepening that crisis?
Do you hear me? Yeah. Yes, yes, I think so. And I think the way the Israeli system dealt with the Palestinian detainees emphasized the crisis, and it's a very big moral crisis. And I think that there was a moral crisis from the beginning, but it deepened and it aggravated in the last 2 years. And I want to show it by showing what happened in these 2 years with the Palestinian detainees and how the court gave back to these policies. When we started to visit 2 years ago the Palestinian detainees, we discovered that all of them were being deliberately starved. Over time, it became clear that this was not incidental, but a clear policy implemented with the backing of Minister Ben Gvir. Detainees who required the basic medication, so they requested ignored. Clothing and hygiene products were not provided in a manner that preserves human dignity. And this was a wide-ranging system of violation, and we didn't witness before. Israeli courts refused to allow lawyers to file a general petition addressing the systematic violations, even though the issues were not tied to specific individuals. And in these were clearly systemic abuse. But the courts insisted on addressing them only through individual petitions, and this emphasized the way the courts and the law tried to keep the situation as it was. Only in this way of submitted individual petitions, we were able to make minor changes in comparison to the cruelty of the violation we faced and continue to face till this day. The accumulation of this petition in some cases lead to minor systemic change. Like in one of these examples was the outbreak of scabies. The disease developed due to extremely poor sanitary condition and the IPS refusal to improve this condition. Despite repeated appeals and despite a long series of petitions filed by many lawyers. So the court know about the scabies and didn't intervene in this case. Unfortunately, I cannot say that we managed to eradicate the disease till this day after 2 years, but we did partially succeed in securing treatment and recovery for many detainees. And the very big issue and the central issue in the in these cases and the detainees cases was the medical neglect. Even before the war, and this indicates to the crisis that we had also before, deaths in prison occurred at a frequency that cannot be described as a natural frequency. The dramatic increase over the past 2 years of the death cases is a direct result of the emergency policies that led to systematic deterioration in detention conditions, including access to doctors in a way that ensures proper medical care. Another pattern was the systemic use of violence against detainees. We documented prisoners who reported broken arms and legs as a result of violence by prison guards, injuries that were never treated. They received no medical care, and the fractures healed on their own, sometimes improperly and with permanent damage. There were also cases in which people died as a direct result of violence and under torture, and the court didn't intervene also in these cases. There was a general problem with access to medical treatment, and in many cases this happened because that detainees who repeatedly request to see a doctor or who were taken to the clinic were subjected to violence by the guards. And as a result, many detainees choose not to request medical care at all in order to avoid exposure to violence. And these facts the court know about and didn't intervene. There were cases in which people died following the progression of treatable illnesses, where medical neglect directly led to the death. These include cases of detainees who died from infection that developed from untreated scabies. We are talking about a very easy disease, which is treatable. I personally accompanied the case of a minor who was arrested while healthy, an athletic child who was 17 years old and who died in prison a few months later. And in the autopsy, we revealed that he had suffered from prolonged starvation, which severely weakened his immune system. His death was caused by an infection that his body was no longer able to fight due to the deterioration condition, and the court didn't investigate it at all. Like, it didn't try to find the people who are responsible of these policies. All of these events that I described are the direct result of the policies in place, whether through the starvation of detainees, the neglect of their health, or the direct physical torture they endure. And the passive backup that the court gave to these policies permitted to this situation to continue. And turning today to the Israeli judicial system is a very complicated question. Throughout the world, we have seen how difficult it is to challenge policies that clearly cry out illegality. Even individual legal proceedings have rarely succeeded, and in some cases, it was evident that the Israeli judicial system provided silent backing to these policies. We saw this in the petition addressing the starvation of detainees, in petition concerning the enforced disappearance of detainees from Gaza, and in petitions seeking to allow the International Committee of the Red Cross to access to prisons. And we are already in the period after the war, and yet everything continues. Deaths in custody are occurring at the same frequency. We reach a number which is close to 100 detainees who died in custody in 2 years. And I see no intention to bring an end to what is happening. Legal efforts continues, but there is no willingness, neither within the prison services, not within the Ministry of National Security, but also not at the general legal system to change this reality. And this day, there is also a public discussion about advancing legislation on the death penalty. And in my view, if we look at what has taken place over the past 2 years, it shows that the death penalty has already been implemented de facto. The promotion of this legislation reflects a lack of willingness to change the situation. It provides also legal backing for the existing reality. And in the absence of pressure from the outside, the domestic judicial, from the outside of the domestic judicial system, it is difficult to see how anything will change in the near future. So I really think that all these things that I described reflect a very deep crisis. And the law and the legal system is deepening it.
Thank you so much, Nadia. That's an incredibly insightful answer. I'm just buzzing with follow-up questions that I would love to ask, but in the interest of time, I'll move on to asking you, Stanley, a question, if that's okay. My question is sort of comes in 2 parts, and you can answer it however you want, obviously. Firstly, why do you think that the United States has been the focus of the 2026 Day of the Endangered Lawyer? And secondly, is there any resistance within US state institutions, including the judiciary and the police, to the targeting of anti-Zionist lawyers in this way? And I just say that because based on my insights practicing here in England and Wales, it seems to me that certainly with this stuff to do with Palestine Action, there is a growing amount of sort of internal dissent. You hear leaks from the secret services. I encounter officers in the course of my job, police officers, and they seem embarrassed that they're kind of, locking up grandmothers for holding up a sign and this sort of thing. So is there any kind of, the second part of the question relates to the US, is there any similar internal dissent within US institutions? Over to you, Stanley.
Well, let me segue in by responding or adding to the question that was asked of Nadia. Zionism, at the end of the day, is a house of lies. It was built on falsehood. It exists on falsehood. It slaughters on falsehood. So we as lawyers can do damage to Zionism by exposing it with truth. And as lawyers, it is our obligation to make sure that the lies that they perpetrate, not just with regard to the genocide that the world now recognizes for the last 2 years, even though it's been silent for 100 years, but we have to have an opportunity. We have to take advantage of each and every opportunity to flesh out with facts. Now, sometimes it sounds like rhetoric, but there's a mountain of evidence of facts that supports that Zionism and Israel and the vast majority of Israeli Jews are engaged in war crimes, crimes against humanity, ethnic cleansing, and genocide. And yes, we can say that, for example, the way we're saying it right now, here and now. But more important, in representing our political clients who have been harassed, who have been targeted, who have been arrested, who have been singled out for supporting Palestine, we can expose the falsehood of Zionism through facts by establishing an undeniable record of what Israel has done, what Zionism has done, what AIPAC has done, what ADL has done. This notion, there are some ads on television in the United States now that talk about, Hamas using schools and hospitals as a subterfuge to protect them. And my response and pushback, even in court filings, is we all know the only people in the world that love their children are Jews. I mean, Muslims don't love their children. Christians don't love their children. Buddhists don't love their children. So, of course, the only one who loves their children is Jews. So everyone else would turn hospitals and schools and programs into the means of fighting. And these are the kinds of arguments that we make, myself and colleagues, and point out in our papers. Some judges get offended by it and say that's not the point that's before us. And it is the point that's before us, because you've got Zionist-supported law firms in the United States today that are in bed with Donald Trump and with the Department of Justice and with the Secretary of State that are pushing a narrative that is white, that is Judeo-Christian, that is anti-immigrant, that is anti-identity, that tries to sell a particular perspective. And getting back to your question, yes, we lawyers are under siege. But the reality of it is, while mainstream media makes a big deal about how this administration is putting pressure on law firms and they are rolling over and sitting and fetching and being quiet, those are not fighting law firms. Those are law firms that represent universities, that represent Wall Street, that represent the military-industrial complex. I don't care about them. They're not going to change anything. Even if they break free and stand up and do 5 pro bono cases a year, at day's end, they still are the fulcrum for a systematic approach in this country that goes after people of color, people that are poor, and people of unpopular politics. So for the rest of us, especially young lawyers, and I work with young lawyers, teach young lawyers, use young lawyers as externs, my view, my responsibility is not just to fight this state, and it's not just to fight Israel, and it's not just to fight other states. And I've handled 1 cases at Interpol. My position is oppression against one is oppression against all, yes, but most of my practice for years has been directed on behalf of Palestinians. But our responsibility in the United States as lawyers is to make sure that the next generation of lawyers in this country that are coming forward are empowered, are not afraid, are willing to fight, understand what the battle is about. I have an extern working for me right now who every 2 or 3 days I'll send a project to them, and within 12 hours I get this brilliant answer. They don't want to do anything else because it's political, because it deals with dignity, because it deals with human rights. And yes, there are some judges in this country that express independence. There are some federal judges that are receptive to the arguments that we're making. Increasingly, there have been some 250 federal actions against this administration that have prevailed. I've got some of them right now. I've got someone who's banned in Europe that I'm representing in Germany, along with local counsel. So the responsibility of us as lawyers is not just to fight the fight and to learn and to use our skill every bit as well or better than the people we fight in court, but to make sure the generation coming behind us feels empowered. I'm not going to say safe, because you're not going to be safe. Because when you step into the battle, when you step into the belly of the beast, when you stand up to the powerful, there's going to be retaliation. There's going to be payback. You have to make personal choices. For years, I get requests from lawyers just graduating from law school that say they want to come to my firm. They want to come fight with me. They want to come do the battle. And they have no experience. Some of them have been externs or interns for me. And I tell them, go out and fight for 3 years. And if you still want to do it, give me a call. Some do, some don't. We are in a unique position of power and responsibility throughout the world right now. The world is changing. You've got desperation from the United States and from the global north. You've got increasing rebellions across the globe. Our responsibility is to make sure that voices can be heard and that we can beat the enemy at their own game and do it with consistency, with dignity, and principle.
Thank you so much, Stanley. Fahad, a question for you. So this is something you and I have talked about quite a lot. Basically, we're talking about imperialism, right? And the way that the world is divided into global north and global south, broadly speaking, right? Oppressor nations and oppressed nations, empires and their colonies. And it sometimes seems like when we talk about the day of the endangered lawyer and we try to interrogate authoritarianism and the government's attacks on lawyers, that there's a sort of slightly racist focus on nation states in the global south. And there's a risk that, states or empires like the British and the US empires get sort of let off the hook. Do you agree that there's a sort of disparity when it comes to talking about attacks on lawyers in that regard? And what do you think we can do about it?
Yeah, I think it's definitely true. I mean, we had an event, Stanley and I were on a panel about 5 years ago during COVID. It was on in January again for the Endangered Lawyers, a parallel event talking about the lawyers of terror suspects who'd been targeted because of their representation of people with acts of terror. And Stanley obviously had his experience. Lynn Stewart was mentioned at that time as well. We had a colleague from India who's talking about how lawyers in India have been targeted en masse. There's a famous case in India about Shahid Azmi. This was somebody who was involved with a jihad group in Kashmir. He was then basically detained. While in prison, he became a lawyer. And then he came out and began defending people who'd been rounded up by the Indians accused of terrorism in the post 9/11 world. And he eventually was accused of being a terrorist by other members of the bar in India. He was targeted. He was eventually assassinated in his office by the state. We had that in Ireland. In the UK, for example, again, going back to war on terrorism, and I'm focusing on these years because the war on terror years was the years where so many excesses happened and became normalized. So even this sort of distinction between the global south and the global north didn't seem to exist because the global south governments were acting hand in glove with the global north at that time. There just seemed to be a complete coalition against Muslims at that time. So you'd have unusual alliances taking place because they needed to extract information. Dirty deals were done with the US, with various regimes in the Middle East and Africa to extract that torture, stuff that they're apologizing for now. But in the course of all of that, in this country, we had lawyers like Mudassir Arani, who was defending people like Abu Hamza before it became a popular thing to defend terror suspects. People like Mudassir Arani were doing it. And her practice at that time was very heavily focused on national security because people, were afraid to touch these cases. And I do have to mention Mudassir because she did an incredible job back then. She, like everybody else, she had her good points and bad points, but she was extremely courageous because the Sun had her headlining every time because she's representing Abu Hamza. They made fun about her hijab, they made fun about her ethnicity, they talked about deporting her. In court, that carried on that racism. She was accused of passing information to prisoners, between prisoners, the kind of stuff Stanley spoke about as well, or sorry, Nadia spoke about. And this was just tolerated, not by the state, just by the state, but by the legal profession as well. And this is something we really need to touch upon, is that it's one thing when the state targets you, but you really feel isolated when your own industry and your colleagues, especially in the so-called human rights, civil liberties world, they remain silent and they snigger and they talk behind your back. And Mudassir got a lot of this. In Scotland, you had Amir Anwar, again, targeted because of his representation of terror suspects. And these are sort of celebrated cases within the Muslim community. We all knew about these people and we sort of looked up to them. But beyond that, there's very little written about them. There's very little articles that people don't talk about the sacrifices that they made. In the US, what happened to Lynn Stewart is absolutely appalling. I mean, I used to work at the Islamic Human Rights Commission at the time when she was in prison, and she was one of our prisoners of faith. And again, what was she accused of doing? Stanley will correct me if I'm wrong, but of breaching SAMS because, she said something on behalf of one of her, or was deemed to be on behalf of one of her clients as a message. And she, even when she got cancer, there was very little leniency or clemency towards her. And this is a solid, civil liberties lawyer, someone who stood the test of time, who did the legal entry a great service. And again, around the world, lawyers are quiet. I mean, you had pockets of exceptionalism here and there, but generally speaking, there was no public outcry. There was no Endangered Day, the lawyer in the US at that time. They're doing it now because their corporate interests are at risk. But when it comes to human beings, that wasn't happening. And I think that's something we have to address, is that why do they get away with it for so long? Even now, has there ever been a Day of the Endangered Lawyers for the Palestinians? Why has there never been a focus on it? The Law Society in this country, just to commemorate the Endangered Day this week, they published a report about how lawyers around the world are targeted by the regulators and by criminal investigations. Right, so they've got all these countries around the world, that the usual suspects. Israel does not feature. The US does not feature. The UK does not feature. I mean, this country. I've written to the president of that law society who published the report this week, and I've asked for in a meeting. I've asked for some assistance. I've asked them to make some sort of intervention. And all I've got back is, well, we can't interfere in regulatory investigations. We can't interfere in criminal investigations. It's not our job to do so. But you're happy to do so in all these far-flung places across the world, but not actually in London, where you actually know what's going on. So there is this problem, and I think the way around it is we have to have these type of events, these parallel events, to talk about the real issue that's happening. And I'm really grateful to Nadia and Stanley for accepting our invitation to attend on this panel, and hopefully it'll be the foundation for bigger events.
Brilliant stuff. So I did have a question, but I think in the interest of time, we've only got a little over 10 minutes left. So maybe I'll jump to some questions that the audience have been asking. So an attendee asks you, Nadia, hi, Nadia, thank you for your incredible work and dedication. Have any Israeli prison medics ever been prosecuted for medical negligence or faced any legal repercussions? Oh, you need to unmute yourself.
Yes. Okay. So I'm not really aware of any healthcare professionals who have been brought to trial. But at this stage, the prison services is trying to conceal the identities of its staff, including doctors. So it's very difficult to know the identity of the people who are involved in these cases. And it's something very important to say, that in the case of detainees from Gaza who were held at military camps, people were being examined by doctors and even underwent medical procedure while blindfolded. So they cannot know who give them medical treatment. And at some point, many people didn't know which kind of medical treatment they get.
Okay, thank you. And then this is a sort of UK focused question, so perhaps one for Fahad, but I suppose we can talk about it in the other legal jurisdictions as well. So Omar Shazad asks, talks about how recent cases in, and I assume this is a reference to David Miller's case against the University of Bristol, confirm that anti-Zionist beliefs can be protected at work under the Equality Act. And so if Zionists are using discrimination law to bring grievances against anti-Zionists, can the same law be used against Zionist linked conduct or beliefs, where it creates a discriminatory workplace? And then Omar goes on to ask, do we have any practical advice on workplace resistance? And it would be great to include, to specifically address wearing Palestine badges at work.
Frank, I think you are best placed to answer that question.
Oh, okay. So I think descending into the arena a bit. Yeah, I mean, every fact turns on its own case. Every case turns on its own facts, I should say. But it does feel like Zionist positions are increasingly collapsing in court. And the main point is that I actually think in my opinion, the terrain has moved on. The argument has moved on from anti-Zionist belief. We've already won that argument. Like the genie was released out of the bottle by David Miller's case. And that case has been appealed to the EAT, and it's, we're waiting for the EAT's judgment. But whatever the EAT says, the law on philosophical belief is so well settled by this point, it's perfectly possible to go into court, go into the employment tribunal, wherever it might be, and to assert that you have an anti-Zionist philosophical belief that's sort of integral to who you are, and that you were discriminated against on the basis of manifesting that belief. In my opinion, the way to actually move things forward at this stage is to start making arguments not only about anti-Zionist philosophical belief, but also to talk about associative race discrimination under the Equality Act. So to state the obvious, associative discrimination is whenever you are discriminated against, not because you have a protected characteristic, but because you are associated with someone who does. So if you have a child who's got a disability and you're refused entry to the cinema, that's a good example of associative disability discrimination. And increasingly, when representing anti-Zionist clients who come into this kind of situation, they've been told to remove a Palestine badge, or they've been fired for posting about Palestine on social media, or whatever it might be. In my opinion, the savvy way to plead those cases is not just to assert, I have an anti-Zionist philosophical belief, I manifested it, and you interfered with that manifestation in a way that was disproportionate, but also to simply say, by behaving the way that I did, by wearing a Palestine badge, by posting on social media, I associated myself with people of Palestinian race, and for that reason, face discrimination. That's the first thing to say. And I suppose the second, shorter thing to say is just to remind people that harassment under the Equality Act talks about unwanted conduct related to a protected characteristic, right? That shortly is what harassment is in UK law under the Equality Act. So you'll notice that related to doesn't require the person alleging harassment to actually have the protected characteristic themselves. And the classic example of this is, a man who works in a workplace and is constantly overhearing sexist jokes against women can sue for harassment on the basis that those sexist jokes are conduct related to the protected characteristic of sex, even though he himself is not a woman. And so exactly the same logic applies to anti-Palestinian harassment. If a workplace behaves in a way, engages in unwanted conduct related to people of Palestinian race, for example, saying, can't wear Palestine badges, they are controversial. As I heard the other day in one of my cases, which is about to come public, the watermelon has anti-Semitic connotations, right? Just staggering, open anti-Palestinian racism. You don't have to be Palestinian to assert that that's anti-Palestinian harassment. So I hope you gives you something to think about. But broadly speaking, the short answer is, if someone tells you to remove your Palestine badge at work, you should probably sue them. Obviously, take advice, but you can probably sue them for that. So switching back to my role as moderator then, another question for you, Nadia, just because I think we're so privileged to have you that I want to prioritize questions that are directed at you. So this next question is, somebody asks, is the general trend for Israelis, or I suppose for the Israeli state, to create laws and policies to escalate their oppression against Palestinians? Or are Israeli institutions like the Knesset members, the IDF, the police, actually breaking the Israeli law? So I hope that makes sense. Like, is it the case that new laws have been passed to make what's happening lawful, or is it the case that a lot of what's happening is actually unlawful under existing Israeli laws?
Like the trend is to keep Do you hear me? Yeah. The trend is to keep the law just a general law, and then you can permit, like the Knesset and the whole system can decide where there is a violation and where there is no violation. For example, in the case of the prisoner conditions, at the beginning of the war, we go to the court and ask to stop the emergency declaration, because there is a very clear violation of their rights. And then we get a decision that say that the IPS is committed to give the minimal rights to these detainees, but there is no definition what are the minimal rights for these detainees. And when you give examples from the international law as the minimal standards that are set in the international law, the Israeli system used to refuse this definition and to use the definition by himself. So in the case of the Israeli state, yes, there is a trend like that, to keep the things not clear in order to use the law as the people with power want to use, in the way they want to use it.
Brilliant. Okay, so final question, which I think perhaps everyone on the panel can answer. And maybe I'll combine two questions because they overlap a bit. So one person says, thank you for all your inspiring resilience and perseverance. Do you still believe that the law holds any power to create meaningful change, considering the state of current institutions that are meant to be upholding it? And another person asks, what is your belief on international law and if it really is fundamental and effective? So perhaps we can take the panelists in reverse order this time to give Nadia the last word. So Fahad, do you want to tackle that one first?
Yeah, I mean, I don't think the law was ever in our favor. That the law is a creation of the imperial powers to preserve their power. And all we can do is try to utilize it against them as best we can. But one really important function for lawyers is to recognize the limitations of the law and recognize the limitations of the courtroom. If we spend our time persuading our clients and everyone around us that the law is the only battlefield, then they've succeeded in narrowing the terrain. I mean, we know that the law it plays a role, a small role, but it's really, for me, it's a tool that we use to just wedge that door open and to get sort of strategic success here and there. But really and truly, the Palestine will be liberated in Palestine by the people on the ground there. What we can do is provide and play a supporting role. And that's what we need to do, and we to recognize that. And the sooner we recognize that, the more effective we can become.
Thanks, Fahad. Any closing thoughts, Stanley?
Yeah, I've often said, I'm been pointed out the Hamas lawyer. Israel claims I sit in the inner circle of Hamas and vote on strategy and on how to proceed. But even that is implicit with patrimony, with this arrogance, the supremacy. Hamas needs a white Jew and anarchist from New York City to tell them how to fight the fight. The nature of the fight, the nature of the resistance is up to people on the ground. But we as lawyers, and my first 5 years, I was a public defender with the Legal Aid Society in New York City. And I had a mentor who taught me, learn how to beat them, learn this game, learn this process better than your enemy, and use it with your principle. So I do believe that the process, if you know what you're doing, if you fight the fight and you outthink and you outstruggle your enemy, you can do well. I just spent 6 years fighting a case of a young man who was sentenced originally to 27 years in prison and got it released, got it lowered to 20 years, and he's getting out in a month. Now that's 7 years we knocked off his sentence. So yes, in terms of on the ground as lawyers, we can make a difference. But we are one small part of a global struggle that involves armed struggle, that involves poetry, that involves painters, it involves writers, it involves women, men, in between, a whole variety. But when we choose to go into law, we need to learn our skill craft, use it, and to outfight those that are the enemy. That's what we can do. In terms of international law, the international law that's most compelling right now is on the ground, and it's got nothing to do with All Rise.
Thanks so much. Finally, over to you, Nadia.
So yeah, I also agree, and I think that the legal work cannot be the sole strategy, and we need the presence of broad social and popular support in these cases. The political power of any discourse cannot be built on legal language alone, and it must be accompanied by action at the social and political levels. And in the case of the Israeli legal system, this dynamic exists very clearly, but from the side of the Zionist majority. A colonial discourse is shaped and imposed first in the political and social arenas, and over time, this power seeps into the legal system. The courts were never truly neutral, but they have increasingly become influenced by the dominant discourse. And as a result, courts are extremely cautious when dealing with issues that are sensitive for these people, for the Palestinian people, and these cautions not for the Palestinian, for the Zionist people. And this caution came at the expense of the communities, the Palestinian, that we represent, that lack political power altogether. And I think this creates a particularly dangerous situation in Israeli society, where it has become very difficult to separate the lawyer from their client, and this explains this situation. And I think that the key is to clearly demonstrate that the legal field does not and cannot stand alone. It must be supported by these social and political actions. And I can see that I saw that very clearly in the cases where we represented prisoners who went on hunger strike. Like legal battles on their own did not lead to result, but when hunger strikes were combined with legal proceedings, we were able to achieve concrete outcomes.
Thank you. That's such a brilliant and provocative and thoughtful note to end on. Thank you, everyone, for joining us for tonight's discussion. We've gone slightly over time, so I'm just going to wrap things up quickly. First thing, if you support the sort of work that we're trying to do here with Riverway to the Sea, the space we're trying to create to critically interrogate Zionism in and beyond courts, to understand that law is enemy terrain, but to nevertheless find ways to intervene there, then please do find one of the links in the chat that will allow you to donate and support our work if you're able to. There are, of course, other ways that you can support us. Follow us on social media, come to our events, and reach out to us and find ways to collaborate. We very much view ourselves as in dialogue with and subordinate to the strategy and tactics of the wider movement. And I just want to end by thanking everyone for joining us for tonight's discussion, and in particular to thank our esteemed panelists, Nadia, Stanley, and Fahad. We hope that this has provided space for all of you to think about the role of law and of lawyers in the struggle against Zionist apartheid and genocide, even as we identify the limits of the role that lawyers can play. As the Marxist legal scholar Rob Knox has pointed out, when it comes to intervening on the terrain of formal legal proceedings, we must find ways to move beyond mere tactics and to embrace instead or to formulate and execute a strategy. So what we're trying to do at Riverway to the Sea is to contribute towards the coalition that forges the strategy that actually defeats Zionism once and for all. So we encourage everyone to continue escalating your opposition to the apartheid state of Israel and its fascist ideology of Zionism. And we look forward to seeing you in the near future. Good evening, everyone, and thank you.